It's 2025 and a new year means brand new opportunities. And for a lot of you out there, I know you've been thinking about one thing over the holidays, and that is starting your own business. But you have so many questions like how do I get started? How do I come up with a brand? How do I even sell stuff to people? And what am I even going to sell? Now take a deep breath. Shopify has got you. Shopify makes it simple to create your brand, open for business, and get your first sale. And you can get your store up and running easily with thousands of customizable templates. You don't have to be a coding nerd or a design geek to get this done. All you need to do is drag and drop. Shopify also helps with the details like shipping, taxes, and payments from one single dashboard, so you can focus on the important stuff, like growing your business. Established in 2025 has a nice ring to it, doesn't it? Sign up for your $1 per month trial period at shopify.com/truecrime, all lowercase. Go to shopify.com/truecrime to start selling with Shopify today. Shopify.com/truecrime.
I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. Welcome back, everyone, to the Prosecutors Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my discerning co-host, Brett.
Wow, Alice, discerning. I feel so not judgmental. That's not the word.
Well, you see, it's not really fair to you because you don't exactly know where I'm going with this, but people who've clicked on this episode know that this is an episode about the role of the prosecutor, which calls for a lot of discernment, and I think you have great discerning wisdom.
I really like how your words always tie into the episode, Alice. I mean, it's a lot of pressure for you to keep doing that, but you did. That was good. That was good.
Look, well, all I'm saying is for 2 years, I've bit my tongue. You know, while you've come up with terms for me, just willy-nilly, out of nowhere. And here I am trying really hard not to be an indictment against the way you've been doing it, but to show you that a little effort goes a long way, Brett.
I see. Yeah, my words are just random. It's like dictionary, adjectives. What's an adjective? And go with that. But yeah, well, I appreciate that, Alice. And you're right. Today we're going to talk about the role of the prosecutor. This is a topic that people have asked for before. It really, after we did the Adnan episode, we got a lot more requests for this. So we were always going to do this, but it just seemed like the perfect time to do it after everything that happened.
Exactly. And after a lot of your questions, it became clear that not a lot of people actually understood the role of the prosecutor, especially at different phases of a case, because your role is the same throughout in terms of what you're seeking, which is justice, but what you are able to do and the tools in your toolbox and how you effectuate that, I guess, opinion of the case changes as the case goes on. And so this is going to be interesting. And I'm sure there's going to be people who disagree, but we are trying to lay out for you what the role of the prosecutor is supposed to be within like judicial ethics.
And one thing I think people should try and remember, and I know that the Adnan case with all the emotion and people put so many years into it and people feel very passionately that he's innocent. It's easy to remember this when you're thinking about a single case, particularly when you care a lot about, but we talk a lot about division of power on this podcast. We talk about that a lot and sort of how it, helps keep you free. And we talk about juries and how important juries are because of the role they play. And, the state can't convict you of anything unless 12 ordinary people who aren't employed by the state at all. They get like a $5 per diem, and that's it. Maybe they get lunch. Unless they say you're guilty, the state can't convict you, and how important that is. And one thing that you should keep in mind as we talk about this is you really don't want power concentrated in one person. Like, you really don't want prosecutors to have so much power that they really do alone sort of hold people in their hands. It worked out in Adnan's case that the prosecutor there wanted to let him go, but what if she didn't? And should it be the case that if she doesn't want to let him go, that she has the final authority and sort of is the only person who can do that? Or do you want it to be sort of more divided up? And I think as you see, when we walk through the way the role of the prosecutor is viewed as the process goes on, you'll see that as it goes on, the prosecutor actually becomes less and less powerful, and their personal opinions of the case matter less and less. And I think it's interesting to think about why. Now, what we're going to do to sort of structure this, there are rules for lawyers in every state, and every lawyer is bound by the rules of their local bar association. So every state has a bar association. You have to be admitted to the bar in order to practice. It's sort of old-fashioned and archaic and probably should be gotten rid of, but don't tell the bar I said that. But in addition to that, there's something called the American Bar Association, which is kind of like, I don't know, a guild or a union or an affinity group for lawyers. I'm not really sure how to describe it. I'm not a member of the ABA. A lot of people aren't members of the ABA, but they sort of exist as this group where lawyers can kind of come together and talk about things in the law. And one thing they do is they will promulgate sort of their view on what the standard should be, and then states if they want to adopt that, they can. If they don't want to, they don't have to. So it's not as if this is binding or anything, but I think it's good to sort of use it to talk about how most prosecutors view their role and how most jurisdictions view the role of a prosecutor. So if you disagree with this, just know this is not written in stone, but we thought it would be a helpful way to sort of start out the discussion.
Absolutely. And it's helpful because, for a lot of people, especially outside of legal practice, they look to the ABA as an authoritative kind of figure, whether that's right or wrong. And so it's probably the most prominent view of the law that's easily accessible to lawyers and non-lawyers alike.
So one thing the ABA does is sort of lays out the role of the prosecutor. And I'm going to read you what they say. The primary duty of the prosecutor is to seek justice within the bounds of the law, not merely to convict. The prosecutor serves the public interest and should act with integrity and balanced judgment to increase public safety, both by pursuing appropriate criminal charges of appropriate severity and by exercising discretion to not pursue criminal charges in appropriate circumstances. The prosecutor should seek to protect the innocent and convict the guilty, consider the interest of victims and witnesses, and respect the constitutional and legal rights of all persons, including suspects and defendants. So, just right off the bat, you can see that the role of the prosecutor is much more complicated than the role of a defense attorney. So a defense attorney has a very well-defined client. It's the person they represent. And their job, subject to ethical rules that we've discussed before, is to zealously represent that person, to do everything in their power to vindicate them in court. And because of that, they really have a well-defined sense of their purpose. Prosecutors, it's much more complicated. And honestly, I think even a lot of prosecutors would have trouble explaining exactly who their client is and how they're supposed to represent that client. This first part, I think, is really important. The prosecutor seeks justice. It's not just seeking a conviction. We've said before, the good thing about a prosecutor is if you're doing it right, you're always wearing the white hat. So if the person is guilty and there's evidence to support that, then you go after that person to seek justice. But if the person is not guilty, or if there's just not enough evidence to convict that person beyond a reasonable doubt, then it's your duty to do the right thing in that case as well and not seek to prosecute them. Lawyers, and you'll hear prosecutors say things that are completely opposite to this. And I hope and I think that this way of looking at things is sort of changing. The old way of looking at things was we just present the evidence to the jury. And it's really the jury's decision. If the jury says they're guilty, then they're guilty. And it doesn't really matter what I think. And my opinion shouldn't be involved there. And we've really moved away from that to the position that the first person to evaluate the evidence and to see whether or not there's evidence beyond a reasonable doubt is the prosecutor. And if the prosecutor can't say that there's evidence beyond a reasonable doubt, then the prosecutor does not need to continue that case.
And that's really important, guys. See, because typically we think of lawyers as just having an advocacy role, right? I would say that's why, in terms of just, looking at its baseline, Brett is right that the defense's role is more defined from the outset. It's from the beginning to the end, advocacy for your client, vigorous advocacy, and that's great. Prosecutor, the advocacy actually doesn't come until later. First, in the entire time, even throughout your advocacy, it is to seek justice. But I would say at the very beginning, before you even decide whether to bring charges, when you're in the investigative stage, when you're weighing your evidence and determining whether to bring charges to present to a grand jury in order to seek a charging document, you have to be guided by justice before your zealous advocacy. And that's kind of why I started out, this descriptor with discerning, because there's a lot of discernment that comes in of whether to charge or not charge at all. Now, once you seek to charge, there's a lot of things to think about. A prosecutor should seek or file criminal charges only if the prosecutor reasonably believes that the charges are supported by probable cause, that admissible evidence will be sufficient to support conviction beyond a reasonable doubt, and that the decision to charge is in the interests of justice. So there's several things at play there. So we've talked about probable cause. It's a lower standard than reasonable doubt. And that's all you need in order to get past the first hurdle of grand jury. And the grand jury, remember, is a jury of your peers who decides whether to actually allow the prosecutor to bring these charges. But that's not enough. It's not just the prosecutor gets to walk into a grand jury if they think that they can meet that lower bar. They also have to believe that they have admissible evidence that can support conviction beyond a reasonable doubt. Reasonable doubt, remember, is the standard you have to meet at trial. This is important because there's a difference between just evidence in general that's in the case and admissible evidence. So what's an example of this? Let's say it's a pretty simple felon in possession of a firearm charge. So someone who's not supposed to have a gun is found with a gun. Let's say there was an illegal search for that gun. The police didn't have a search warrant, had no probable cause to stop someone who was driving within the speed limit, using all their turn signals. And, the cops were just like, no, we want to stop this guy. They roll up to the car. Nothing is amiss. This guy has followed all the rules, and they order the guy to get out of the car, and they search his car, and they have no right to do so. And they're violating that guy's constitutional rights, and they find a gun. Even if that guy was not allowed to have a gun, there was going to be very good reason to believe that search and the fruits of that search are going to be suppressed. And therefore, that prosecutor, even though they ultimately know a gun was in that car, they have reason to believe that will not be admissible evidence. And therefore, without that evidence, they're not going to be able to prove beyond a reasonable doubt that this person who was not supposed to have a gun in fact has a gun. In that situation, they shouldn't be bringing that charge, even though they know more than will be ultimately admissible. And then again, we hear this. All of this is surrounded and shrouded in seeking justice. And this makes sense, right? The prosecutor is paid by taxpayer dollars, and they're supposed to be really working in the interest of making sure justice is met within the society. They're not supposed to be, getting notches on their belt or number of convictions or, any sort of self-serving sort of metric. The metric is honestly very lofty. It is justice.
And this, in many ways, is when the prosecutor's at their most powerful. So the individual prosecutor at this point in the process really has all the power. The prosecutor is the one who decides whether to bring a charge or not, whether to put it in front of a grand jury. The police can want to indict all they want. And with some weird exceptions, if the prosecutor doesn't want to indict, it's not indicted. The prosecutor doesn't bring it forward. This last bit, the charge is in the interest of justice. What does that mean? Well, there's a couple things it could mean. The first is, are there things like Alice was talking about, constitutional violations that go beyond just the fact you won't have enough evidence, but just the fact that those things happen mean that charging that person would be sort of an affront to justice, even if they committed a crime. And that may seem strange to you, but as we talked about in our discussion of the Adnan Syed case, the process really matters, and the system really matters, and the protections really matter. So yes, the individual case matters, but you have to think bigger than that with all these cases. And sometimes that means you'll have somebody that you think is guilty, but you're not going to prosecute. Maybe the other thing could be, a situation where you look at the facts and it just doesn't seem that egregious. I remember a case I dealt with once where there was a guy, he was a felon in possession, but the firearm he had was barely functional, if it ever was. It was like in the back of a junk drawer. I mean, it was one of those things where technically it met the elements, but it was just, do you really want to seek a conviction against this person? Is that the intent of the law? Or is it one of those things where you seize the gun, tell them not to do it again, and then send them on their way? The other thing, interest of justice. Think back to the Redonda Vought case. We had a lot of discussion about this. Was it in the interest of justice to prosecute her? And people were really divided on that. Some people thought it absolutely was. You have a victim who died excruciating pain. There was a lot of malpractice here. We should prosecute her. But other people thought, no, she suffered enough. She's lost her license. She's never going to be a nurse again. All these reasons that it really wasn't in the interest of justice. And those are really difficult decisions, but they're decisions that really are entrusted to the prosecutor themselves at this point. So at this point, the prosecutor probably has more power than they're ever going to have. This initial decision, are we going to move forward or not? So after charges are filed, so you filed charges, now you've gone to the grand jury. So the grand jury, you got to show probable cause. You got to show that this is likely a crime. They return an indictment. Now you're going to go to trial. You have to prove it beyond a reasonable doubt. At this point, you still are looking at the evidence. You should continue the prosecution only if you reasonably believe that probable cause exists and there's admissible evidence. So you've got this sort of reasonable belief. So basically the same standard. You feel pretty good about this. Nothing has popped up to make you think, I have reasonable doubt. And now that I have reasonable doubt, we have a problem. And once again, this goes to what I was talking about earlier, with some prosecutors don't feel this way. They really think it's just my job to deliver the evidence, but that's not the case. You really do have a responsibility to evaluate the evidence critically. And if you decide that not only is there not probable cause and not enough evidence to support a conviction beyond a reasonable doubt, but that the defendant is actually innocent, at that point you have a duty to dismiss the charges. And no matter what your evidence is, I mean, if you come up with something, and this kind of goes back to the DNA thing, right? So you got all kinds of great evidence, and then all of a sudden you get a DNA report that it was somebody else. Well, it doesn't really matter how good your evidence was. At that point, that's a case you need to dismiss. And so at that point, you need to stop.
Yeah. So notice this iterative process the entire time. And some of you may think, well, how could you possibly change your mind as the case is going on? Especially when you're preparing for trial and you interview people sometimes for the first time, or as witnesses realize they're about to take the stand, their stories sometimes change. You do find out new things at times. And so it is always, I know I'm constantly looking through my file, trying to see something that I missed the first time. And it's not unheard of. Both of us have seen, I haven't personally had to dismiss charges after they were filed, but we've certainly had colleagues who've had to, and rightfully so. So it's not something that never happens.
And it's not something you want to do. And it's commendable when you do it.
It's saying mea culpa, which is good. It is good to say mea culpa. I will say this, it's a very serious decision when you choose to dismiss those charges, but I have never spoken with a prosecutor who was in that situation who declined to dismiss those charges because they weren't willing to take fault. So that is the good thing. It is saying I messed up, but we are called to do that. We are obligated to do that, in fact. And I would say, every prosecutor I've worked with takes that obligation very seriously. Now, what happens after conviction? Let's say, the prosecutor has prosecuted this case from beginning all the way through conviction and had the evidence for it, believed in their case, and they went through the, adversarial system, and there is a conviction. Well, the prosecutor at this point has a duty to defend the conviction obtained after a fair process. Now, this duty is not absolute, and the prosecutor should temper the duty to defend with independent professional judgment and discretion, of course. But the prosecutor should not defend a conviction if the prosecutor believes the defendant is innocent or was wrongfully convicted, or that a miscarriage of justice associated with the conviction has occurred.
And that's, very vague. What exactly does that mean? And so the ABA helpfully provides some sort of further discussions of that. What does it mean you no longer believe that it's a valid conviction, or now you think the person's innocent? Is it simple as, well, I've just changed my mind? Is it as simple as that after its conviction? The answer is no. There's actually a little bit more nuance to it, and nuance to what you do with evidence and what kind of evidence you're looking at and how strong that evidence is, how you handle it, what you have to do, and what your obligation is to the defense.
Yeah, so we'll read that to you. Now listen to what it's saying, because as Brett said, it is nuance. So The guidance says, when a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall, 1, promptly disclose that evidence to an appropriate court or authority, and 2, if the conviction was obtained in the prosecutor's jurisdiction, promptly disclose that evidence to the defendant unless a court authorizes delay, and undertake further investigation or make reasonable efforts to cause an investigation to determine whether the defendant was convicted of an offense that the defendant did not commit. There's more to this guidance, but no, so far, the guidance has not said anything about vacating a conviction. All it said so far is the duty of the prosecutor to let basically everyone in the adversarial process know about this new evidence that they have. The defense, the court, any other authority that needs to know about it. Okay, so the first is this needs to go through the adversarial process because everyone needs to know about this new evidence and further investigation needs to be done.
And one thing that's really interesting about this, up to this point, the rule has been if the prosecutor has a reasonable doubt about the guilt, the prosecutor should seek to dismiss the indictment. The prosecutor shouldn't move forward. Once a jury has made a decision, though, that changes. Here you have new, credible, and material evidence creating a reasonable likelihood that the person didn't commit an offense. That's reasonable doubt, right? You got evidence that's material, that's credible, and now all of a sudden you have this reasonable likelihood, not even doubt really, but reasonable likelihood that a convicted defendant didn't commit an offense. Even at that point, even with that much, your job is not to dismiss the conviction. Your job is to take that evidence and give it to the appropriate person. So give it to the court if that's what you're supposed to do, or give it to the defense so they can look at it, and then you can continue to look into this and see if there's evidence that rises to an even higher level, which we'll talk about in a second. But that's your responsibility.
And part of the reason that is because no longer as this case has moved through the judicial system, is the prosecutor really the puppet master, if that makes sense. If it went through trial, there was the judge making all the legal rulings. There were the 12 jurors who listened and were charged with making findings of fact, and they reached a decision. So for one person to come in and basically say, nay, everything you said, 12 people who sat through however many days or weeks or longer of trial, your opinion doesn't matter. Everything you debated doesn't matter. This one person. And why is it the prosecutor who gets to be that person who says, why isn't it the defense? Why isn't it one of the 12 jurors who gets to do it? Why isn't it the judge? And part of it is because there's this whole process that's built together. And as it moves through the process, as Brett mentioned earlier, the prosecutor kind of gets less and less authority over the process. And there has to be some respect for the other entities that had played a role throughout the judicial system.
We got some feedback on the whole Adnan thing that we focus on process too much. That why are we talking about process? We should just be talking about justice or whatever. Well, I think the thing that we've sort of learned as a society, that the best way to get to justice is to have process. That's why your due process rights are so important. And you have this tension in the legal system between victims, justice for victims, upholding the rule of law, and ensuring that innocent people aren't convicted of crimes they didn't commit. And there is a tension there. And the prosecutor, remember, in the beginning, their job is very much to make sure that they are not charging and attempting to convict someone who's innocent. But it begins to shift. And once there's a conviction, as we read you, all of a sudden you have a new duty. And it's a duty to defend the conviction. And you only turn your back on that duty if you've got some real reason to do so. And you start to see that, as Alice said, it's not just up to you. I mean, there's very much a who decides and why them with this. And usually it's not going to be one person. It gets more diffuse as you go along. So prosecutor can charge, but they can't convict. We need a jury to do that. Prosecutor can recommend a sentence, but they can't sentence. We have a judge who does that. And you see sort of by breaking up these powers and separating them out, you're ensuring that both the rights of the defendant and the rights of the victim, who often get forgotten in this whole process, are respected.
So the guidance goes on. When a prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecutor's jurisdiction was convicted of an offense that the defendant did not commit, the prosecutor shall seek to remedy the conviction. The standard here is something akin to the standard for a judge to overturn a jury verdict. Is it the case that no reasonable person could convict based on the evidence?
And clear and convincing is basically one of the highest standards you have in sort of an appellate situation. It has to be basically unquestioned. This is obvious. It's so clear. It's so convincing. We got this one wrong, right? So short of that, what you're doing is you're giving information to courts. You're giving information to the defense. And they can use it as they will. Maybe they're going to file something. If it comes to you and it's so clear and it's so convincing, then that's a situation in which you should take it upon yourself to seek to have a conviction vacated. Usually, not in all cases, as we learned recently, usually a judge is going to sort of hold you to a pretty high standard there to prove the clear and convincing evidence. And usually you're going to have evidentiary hearings and you're going to have a lot of discussion, and this is going to be a pretty high bar because it's a big deal to overturn a jury conviction. And it's a big deal for you as a prosecutor just to decide to do it. And I think one of the things you have to ask yourself whenever thinking about this, what does clear and convincing mean? I mean, look, some of that's going to be a little fuzzy, but generally speaking, it should be the kind of thing that if a reasonable person heard it, they would agree with you. And that's where you get to this whole no reasonable juror. So there are different standards in the law, and this is really confusing. These whole standards things are very confusing. One day we'll do something about that on its own. But for instance, you might have a circumstance in which the court asks, could any reasonable jury convict? And as a matter of fact, that is the standard for a lot of things. Like if any reasonable juror could convict, then we're going to uphold this. And sort of the same as that, but written in an opposite way, is this notion that no reasonable person could convict. That there's just no way anyone who was reasonable, who heard this evidence, would believe the person's guilty. And if you reach that point, then that's when it's time for you to take some really difficult steps and make a decision. We talked about the whole Adnan Syed case. There are some of you out there who probably think it was clear and convincing, that whatever evidence there was clear and convincing, and they should move forward with that. And I don't know. I know there's a lot of people who would disagree with you, which kind of makes you wonder. But when I think, even though it wasn't explicit, and it wasn't explicit in their filing, and really there wasn't a lot of discussion about this standard in their filing, I think what Baltimore was trying to say is I say this, I'm trying to give them the benefit of the doubt that they said that. But then the problem is, if you go back to their filing, they actually say they're not saying that Adnan Syed is innocent. And that kind of really tripped us up, when we talked about it. And we got a lot of people who were like, oh, but, I read this book and there was all sorts of great evidence in there. And there's a great podcast that talks about it. You guys should listen to that. You really need to look into this. And as we said, it's not really about that. The question is Baltimore saying that they have reached this standard, this clear and convincing standard? And it's a little strange to say it's clear and convincing that they didn't commit the crime, but we're not willing to say they're actually innocent. We're not willing to say we're not going to retry them. We're in the middle of our investigation, and they have to go home to house arrest. So I don't know. I don't want to rehash that whole thing. We spent an hour and a half on it, but I think it is interesting to look at that through the lens of these sort of standards that are applied to prosecutors around the country. What is the purpose of all this? As we've said before, one of the jobs of a prosecutor is not to convict innocent people. And the first person who should be a bulwark against innocent people being convicted is the prosecutor. And we've heard a lot of people, and we hear it all the time, that will say, the system is broken and we need to fix the system, we need to replace the system. Very few people have a good idea of what they would replace the system with, but I think it does raise a question about how bad is this problem. It is very easy, and this is true really in every facet of human life. It is very easy to focus on the things you hear about and to believe they are more prevalent than they are. Take plane crashes. I'm terrified of flying. Terrified is probably a strong word. I don't like to fly. And every time I get on a plane, I'm like, well, if I die, it's been a good life, right? Even though, as we all know, much more dangerous, the drive to the airport is much more dangerous than getting on the plane. And as a matter of fact, thousands and thousands and thousands of flights happen every day without a plane crash. But when a plane crash happens, it's a big deal. And a lot of people die, and you really focus on it, and you hear about it, and you remember it forever. There's just famous examples of plane crashes, right? And so in your mind, you magnify those things, and you come to believe, because you hear about the big plane crashes, and you don't hear about the planes landing safely every day, that flying is really dangerous. It's the same kind of thing here. In true crime in particular, we hear about wrongful convictions all the time. There are a lot of people who put a lot of focus on potential wrongful convictions. So how common are they? Well, there was a study in the Arizona Law Review recently. We'll link it on the website. You'll often hear, the highest number you'll hear for wrongful convictions is about 4%, but I think pretty much everybody agrees that is way too high. And the more common number you'll get is 1%. And that's still pretty high. I mean, 1 out of 100 is still pretty high for a wrongful conviction type thing, particularly given how many people we have in prison today. That number adds up fairly quickly. So there was a study in the Arizona Law Review that attempted to do a little bit more of a methodical look at this. And it's been criticized by plenty of people, so feel free to disregard it if you want to. We'll post it online. You can read it. But the error rate that they found for violent crime convictions was about 0.016% to 0.062%, which much lower than 1%. And they compared it to the risk of being a victim of violent crime, and I thought this was actually pretty illuminating. And so they compared the risk of being a victim of violent crime to the risk of being falsely accused of a crime. And the number was about 30,000 to 1. So 30,000 to 1 is your risk of being a victim of a violent crime versus being falsely accused of one. And this led the author to opine, this decidedly skewed ratio suggests that reform measures for protecting the innocent may need to be cautiously assessed to ensure that they do not interfere with the important goal of prosecuting the guilty. And that really gets to the tension here and what you really have to struggle with. We all know of cases where clearly guilty people got off. We all know of cases where we feel like justice wasn't done, and you're constantly having to balance these two things against each other. We don't want innocent people in prison. One day for an innocent person in prison is hell on earth, and we don't want that. And we want to make sure it doesn't happen, but we have to balance it against justice for the victim, the safety of the community, all the things the justice system is supposed to do. And so I would just say, as we have these discussions, and we've been having these discussions, they've been great, very respectful. If you guys aren't on the gallery, you're missing out because there's been some great discussions. But as you're having these discussions, just remember there is a balance. And when you stray too far to one side, when you upset the process, what you're going to end up doing is having a lot more guilty people on the streets and having a much more unsafe system. So process matters. At the end of the day, process is what protects us, both from being convicted of a crime we didn't commit and being the victim of a crime. And we have to focus on that, even if there are times where the case itself really pulls us and we really want to focus on that and decide that it's a symptom of a bigger problem. And maybe it is, but just be careful what you wish for.
And, we've talked about this a lot before, but part of the reason that process matters is that process is cold and hard and unfeeling. And that's actually what you want when you're looking at the equal application of the law. And it's something that's, kind of worked on throughout our common law practice to try and get to as close to perfect as possible. But these are costs and benefits that are being weighed on, everyone in the legal system's minds when we are thinking about reform and changing the processes in place to protect both the wrongfully convicted as well as potential victims out there. And they are directly correlated with each other. The rise in crime is, correlated with people not being punished for what they're doing, or people, getting out and being able to recidivate quickly, especially violent criminals. And it's a balance that we have to strike as a society, and it's a conversation that's very important. And I don't think there's an easy answer. If there were, then we'd all be at 100% of, conviction of people who should be convicted and, victim rates would fall drastically because, if you commit a crime, you're going to be convicted and have to serve your time for it. But we're not there yet. And here's the thing. The justice system is made up of humans. Humans are imperfect beings. It's never going to be perfect, but it doesn't mean we don't keep striving to get as close as possible. And you get closer every day when you have prosecutors and defense counsel, but in this case, since we're talking about prosecutors, in those positions of power where they use that discernment to seek justice first and not just to do whatever one sole prosecutor feels they want to do that day, whether that is to go after, a conviction that should not be sought, or to vacate a conviction that has justly been found after a trial. And these are all because we've decided not to concentrate the power of someone's constitutional liberties in just one person. And personally, I'm glad of that. As a prosecutor, I wouldn't want all of that power because I don't think that's right. It would mean that I'm always right 100% of the time. And I know that's not the case for me. And if I were the one being accused of a crime, or if I were the victim, seeking vindication for what I've suffered, I would want to know that all the power isn't just concentrated in one person, because the whims of one person, all of us can say that we're the most reasonable person in the world, but we are all subject to whims and biases and blind spots. And that's why the process exists, to try and create a system where there are many safeguards in place and many pressure points to challenge whoever is advocating's position, to make sure we try and strip away the extraneous, the biases, the blind spots, to try and get as close to the truth as we can.
And when you talk about process, all you mean is the means. All you mean is the means to an end. And, that ultimate question, do the ends justify the means, or do you have to make sure that the means are just? And if the ends justify the means, then you're going to have a big problem. Because one of the whole keys of our system, our constitutional system, is that even if you are guilty and you should be convicted, if, say, your right against illegal search and seizure was violated, we're going to suppress the evidence that would be used to convict you. And so you're going to be freed. That's not an end anyone likes. We don't like the fact that a guilty person is getting off, but we've decided that in order to protect everyone's freedom, we have to ensure that the means by which we seek justice are themselves just. And once you start saying, well, whatever, I don't care about all that. All I care about is this thing that is really important to me, and I want to get to that. And if whatever it takes to get to that is fine, that's what I want to get to. Once you go down that road, you are on a dangerous, slippery slope, and it's pretty easy to make the argument the other way as well. So you can call it process, you can call it justice, you can call it whatever you want to call it, but ultimately, it's our adherence to that belief that ensuring a just process is what matters, that protects all of us, guilty and innocent.
So we hope we've at least answered some of your questions. It probably raises more, but that's what we're always here for. And we just want to thank you guys again for all your support. And, we said we'd never cover Adnan. And when we finally did as a legal update, we were so impressed with your thoughtful comments, even when you disagreed with us, which we always welcome. And you're incredibly compassionate, but also civil discussion, especially on the gallery, which is our Facebook fan page. And we want to thank you guys for that, because that's the whole point, right? We put these out to hope and inspire good conversation and discussion, because the more you know, the more you're able to participate in that discussion. So with all of that said, Brett, do you have anything else you'd like to add today?
Just, we've had so many listeners, we're just going to do Adnan every time. So every episode from now on is Adnan Syed. Tune in every week.
Oh, gosh.
No, I think this is the last time we're going to be talking about Adnan for a while. I think that case is probably going to go pretty cold at this point. But if not, hey, we'll be back. We'll be back with any updates. When the real killer is arrested, we'll talk about that.
Indeed. Well, thank you guys for all your support on this podcast and also on our other podcast, the Prosecutors podcast. And thank you for leaving your 5-star reviews. And most importantly, thank you for telling your friends about us, because we are the worst business people. We don't advertise very well. We've grown organically because of your word of mouth recommendations. So we just want to say thank you. We see what you're doing and we really appreciate it. Keep writing into us on these great ideas for episodes, and we will keep covering them. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs.
Glasses are a lot of fun.
Now you're having me Google hourglasses.
Now I kind of want to get an hourglass.
I do too, because they're
I'm going to work for an hour
hypnotizing.
and then like turn it over. No phone for an hour. Turn over my... Well, you know, my bad habit is I'll have like a brief up and I'll write like 2 sentences. And then it's like, okay, gotta check my phone.
I literally did that when you texted me to record. I was like, 1 sentence into a brief and you're like, want to record? I'm like, yeah, of course. Sure do. Can think of nothing else I'd rather do right now.
And it's like, oh, well, I guess I should write some more sentences. And I write 2 more sentences. And then it's like, okay, I gotta check my phone again.